We've got oral arguments for the Rhode v. Bonta case set for December 4th. That, of course, is CRPA's challenge to the ammunition regulations from Proposition 63. It's time for that refresher course. Where did this case come from, and where is it going? Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we have oral arguments for the Rhode v. Bonta case coming up here on December 4th. Thought it'd be a good idea to get a little bit of a refresher to see what exactly we are talking about when we're hearing the arguments for this case. To do that though, we have brought back the CRPA volunteer president, that is Chuck Michelle. Chuck, thanks for being with us today.
Sure. Thanks for having me, guys.
Absolutely. But before we get into that, everybody, please be sure to like, share, and subscribe to this video. It really helps with the algorithm. We want everybody to have the most up-to-date information with this litigation. And of course, by liking, sharing, and subscribing, that is a direct opportunity for you to contribute to Second Amendment litigation like the Rhode v. Bonta case. So, Chuck, just as a little bit of a refresher course, as we're looking forward to these December 4th oral arguments at the Ninth Circuit, what exactly happened with Prop 63 that forces an organization like CRPA to sue, and what are the arguments that were made in this case?
Well, Prop 63 was a conglomeration of bad gun control laws, all pushed by Gavin Newsom as he was using it as a platform to run for governor, kind of like he's using the 28th Amendment to repeal the Second Amendment as an excuse to run for president, which we will going to hear a lot more about that in the coming weeks after the Trump transition goes through. Gavin will be staking out his territory for the 2028 presidency campaign. But anyway, one of the things Prop 63 passed was a ban on interstate importation of ammunition to individuals. So you can't order ammunition through the mail anymore, and a background check on every purchase of ammunition that you every time you buy ammo at a gun store. And they want to know all kinds of things like the type of guns that you have. And there's a couple different ways to get the background check done. You can pay $1, and they're trying to jack it up to $5. And they'll search the automated firearm system, which is basically just the firearm registration system. And if you have a registered firearm, then they'll use that as the background check. Problem with that is there's at least a 10% incorrect denial rate when people are just running through the AFS system, the dollar system. And so many people, it becomes such a problem if you get denied. It's such a hassle to try and straighten things out. And we do this, my law firm does this for people all the time, straightening out the DOJ's records for criminal history or firearms ownership or whatever, because they're a basket case. The systems that the DOJ manages relating to firearms, and not just that, take a look at voter registration. They're a mess. So lots of people get denied. 60% of the people who get denied don't go on to do the work to fix it so they'll be approved. So then, or they can opt for a $19 background check, which is a full, basically, same as a check you would do when you buy a firearm. But there's like 90% record errors when people do either. So a lot of times it's something simple, like the address doesn't match up, or the name is spelled wrong, or there's two people with the same name. But again, it's just a constant hassle to get the DOJ to actually get off its butt and fix these things. So it's had a huge chilling effect on the purchase of ammunition in the state of California. And all of those obstacles really come down to a Second Amendment violation. So we challenged this law when it first passed. It went up. We won in front of Judge Benitez in the San Diego Federal District Court. It went up to the Ninth Circuit and was then held there because Duncan, the magazine capacity challenge that we also filed, and we also won in front of Judge Benitez, and then won again in front of the three-judge panel in the Ninth Circuit, was in the Ninth Circuit. So everything was bottled up behind Duncan. And then Duncan, we lost 7-5 on the three-judge panel. It went up to the Supreme Court. Meantime, Rhode was still frozen. as along with several other cases. Then it came back, then the Supreme Court granted review, vacated the Ninth Circuit en banc ruling against us, sent the case down for reconsideration. Duncan was sent back down. Rhode was sent back down to Judge Benitez again. We won both of those again. Duncan went back up first. Duncan is now sitting. It's been argued to an en banc panel. We're waiting for the decision. It's been argued. It was argued last March or April, and we're waiting for the Ninth Circuit to rule. Meantime, Rhode is once again held up, stayed behind, awaiting on the Duncan decision, along with several other cases. So we're very hopeful because the decision by Judge Benitez was very thorough, very long, a lot of footnotes. There is no historical analog for a ammunition, essentially red taping system. It's not even just a background check. It's much, much more than that. But the state is arguing, this is analogous to a background check for buying a firearm, so it shouldn't make any difference. Never mind that, there's 1,000 times more ammunition purchases than there are firearm purchases. So it's in the Ninth Circuit. The oral argument will be December 4th. And it will I'm assuming that it will be stayed again, waiting, or it won't come out until after the Duncan decision comes out. And then part of the Rhode ruling will be based on whatever the decision is in Duncan, as the Ninth Circuit probably tries to mess with the Bruin methodology and distort it so that it can uphold the gun control laws that certain biased judges on the Ninth Circuit want to uphold. And if you haven't read this month's CRPA magazine yet, we have the judicial two-step is the cover story with 3 judges dancing on the cover. And the article inside explains how courts try to distort Bruin to uphold all manner of gun control laws that should be declared unconstitutional.
Well, I'm sure that we'll continue to see that in the courts and make it as difficult for judges to do that as possible with things like the arguments in the lawsuit or in oral arguments. There was kind of a lot there that was packed in. I just think it's important for everybody to understand, by winning a case like this, we do have an opportunity to reclaim the ways that we used to purchase ammunition, that is without having to pay a fee. Like right now, you said it was $1. This year, it looks like with legislation, they're going to try to push it to $5. As well as being able to purchase ammunition across state lines, which there's a lot of places out there that you can order ammunition and have it delivered to your doorstep, but nope, not in California. And I think it's also important that you pointed out, aside from losing the opportunity to purchase ammunition that way, there were people who were just literally stripped of their Second Amendment rights when trying to go through this background check for no fault of their own. You literally have a back-end DOJ system that was incorrect, which forces somebody to, not be able to purchase ammunition because that information is correct and the background check doesn't clear. So I think it's important to understand at least that foundational part of a lawsuit like this. And then, like you said, kind of taking the same path as Duncan. It's been through Judge Benitez twice. And even the second time it went through Judge Benitez, right? We even got a Rhode version of the Freedom Week like we saw in Duncan, where, I don't know, it was for a few days, right, that we were able to bring ammunition in. So the lawsuit itself has already, proven to benefit Californians in that way. I want to pick your brain on the oral arguments that we have coming up. You mentioned the oral arguments that we had with Duncan, which was extremely entertaining for somebody like me. Some people might call a little bit of a show. It seemed like at least the en banc oral arguments, they were discussing more about who should be hearing this case than the case itself. What exactly do you expect to be discussed at the oral arguments for the Ninth Circuit?
Well, we don't know who the judges are yet, so that's going to have a lot to do with it. If we get a good panel, the Ninth Circuit used to be 1/3 conservative president appointees and 2/3 progressives. Now it's about half and half. So really, statistically, we have a much better chance of getting a decent panel. And unfortunately, a lot depends of the result. The result often depends on the panel that you get. So I expect there will be a lot of questions about Bruin and how Bruin should be applied, and whether or not there are historical analogs that would justify historical analog laws that are similar enough to this modern law that it would be, tolerated by the founding fathers. That they don't have any that really match up to this. So that's kind of, I think, where the focus will be, unless we get a hostile panel who just wants to say, this is just a background check that, and the fact that you have so many database errors and so much inconvenience that falls on the shoulders of the person who's trying to exercise their Second Amendment right, that's a small price to pay. Work your way through it. Gun ammo buyer.
Right. I'm also kind of curious if there's one way that a federal election like we just went through can potentially influence the court system. It's with the Supreme Court, right? It's the president who appoints, and then the Senate confirms justices for the Supreme Court.
Every district court appointment, every circuit court appointment, that's all done by the president through the Senate. And Trump doesn't have anywhere near the number of openings that he had during his last term, because Biden tried to fill a lot of those. But he has enough, and there will be some judges that will retire. You may very well see a couple of the conservative judges on the Supreme Court retire now that Trump is in office, because they're getting up there age-wise. So they may take this opportunity in the next 4 years to retire, and we'll get a couple new ones that Trump will pick.
Well, that's actually kind of what I wanted to hit on with you, at least from your experience with a potential outlook over the next 4 years of having Trump in office and seeing the justices that he's already put on the Supreme Court with the potential for 2 more. In your experience through all your years of litigating in the Ninth Circuit, does that have any kind of effect on the way some of these judges look at these cases and decide these cases, or is it just the way that this judge interprets the law is the way they interpret the law?
It's definitely a factor. And look, when you have 50-50 split on the Ninth Circuit, they talk in the hallways in each other's chambers behind the scenes. They discuss cases. So when you have 2/3 of the judges that are all thinking along the same progressive lines, they're not as likely to be influenced by the other more conservative justices. But when it's 50-50, there's a possibility of a more robust debate and maybe some minds being changed. And that's a big question that really is going to foretell what comes in the Duncan decision. Remember, we lost 7-5 before. Yeah, I think it was 7-5. Anyway, if we change 2 minds on the en banc panel, or if some of the conservative justices that were on our side the first time around on Duncan can change 2 minds now that Bruin has come down, we could win. So yeah, and all of them are thinking about retirement and who's going to replace them. And there are some senior conservative judges on the Ninth Circuit too, and in the district courts in California and Ninth Circuit states and across the country. So yeah, it makes a big difference. Unfortunately, that federal judges are appointed for life, and so the only way you get rid of them is when they retire, and then so that's where the president's appointments come in.
Well, certainly, at least from where this started in 2016, a lot of optimism looking forward. What are your final thoughts on Rhode itself and the oral arguments coming up on the 4th, and where this could go after?
Well, first of all, keep in mind and thank Kim Rhode, the Olympic gold medalist trap shooter, sporting clay shooter. We should all know and love her and support her. She does great things, and she's an advocate as well as a heck of a shot. So, I've known her for years, and she's always been very supportive, and she's our lead plaintiff. So that goes a long way, because for her and folks who shoot a lot, go through a lot of ammunition, this is a real, not just an inconvenience. I mean, it makes certain things impossible for her to do. So that's one of the reasons why we liked her as lead plaintiff. But anyway, people should be thankful to her for helping us out. And other than that, it's just, look, there's a national fight going on. It's still centered primarily around the Bruin standard. I believe we just got a conference state in the Supreme Court in the Snopes, formerly the Bianchi case, challenging the assault weapon ban in Maryland, that the Supreme Court may very well take. And so that could be the next game changer that we really need if they finally make it clear that you can't ban commonly owned semi-automatic firearms that law-abiding people choose for sport or self-defense or whatever. And the only other thing I'd point out is we just got a great win in Illinois in the district court. The Seventh Circuit and some of the other circuit courts of appeal are trying to throw this military use test in there that's saying AR-15s are so much like M16s that they can be banned just like machine guns are, fully autos are. And the district judge in Illinois distinguished that and said, no, AR-15s are not like M16s for a variety of reasons. And the point of this is that this case is now precedent. It will go up on appeal to the Seventh Circuit again, but it's now precedent. It's persuasive, just like Judge Benitez's opinions are persuasive. He documents them thoroughly, and so did the Illinois judge. So we're building this body of a record where judges are getting it right and applying Bruin faithfully. And that's a snowball that's continuing to develop. And then I fully expect we will see the Supreme Court use when they address the next Second Amendment case they're going to wind up addressing.
Well, you said it when Bruin came out a couple of years ago that the reckoning was coming. It certainly seems like the reckoning is here. We're going to continue and follow along with all of these cases, but more specifically Rhode, which is coming up here in just a couple of weeks. Chuck, I know you're a busy guy. I want to thank you for coming on and sharing with us.
Thanks for having me, Kevin. And thank you, everybody who's watching, for supporting CRPA. We've got our hands full, but we're fighting the good fight. And with support from members and donors, we'll keep fighting the good fight for everybody's rights and for our future and our children's future.
Absolutely, we will. And guys, if you like content like this, you like these kinds of videos, staying informed on Second Amendment litigation, legislative, and programmatic efforts in the state of California, please, once again, be sure to like, share, and subscribe to these videos. It's a way for you to directly contribute to all of these causes in California. Thanks again, guys, and we'll see you on the next one.